Yes.
My lords, my lady, I appear for the appellant in this matter, together with Mr. David Selwood. My learned friend, Mr. Colin Toman, King's Counsel, appears for the respondent, Secretary of State. My lord, before I begin, could I just check that you have all the documents which are available in this case?
Yes.
Been lodged with the court. There's a core bundle,
Yes.
123 pages, a supplementary bundle of 114 pages. There is also a legal materials authorities bundle of 31 items. We have also filed and have permission for an appellant's supplementary skeleton argument, which should be with the court. And very recently, and with our apologies for this, we have filed a chronology yesterday. I have hard copies with me.
Yes, got
we
that.
thought better late than never, but it is our fault, and we should have filed it earlier.
Do you have that?
Even better earlier.
Yes, but would have been, my lord, yes.
Thank you.
I'm grateful. My lord, with your lordship's permission, I propose to develop this appeal in the following way. There were questions posed in the grant of permission by Lord Justice Edis about some issues in this area to do with the authority of country guidance cases, the question of bad faith, and the question of how that impacts on cases. We've set them out, our answers to those, in our supplementary skeleton argument. And there's no material difference between the parties as to those positions. I propose to deal with those at the end if the court has any questions on those matters. They're agreed, and there is, if you like, an orthodoxy on these issues. And I needn't trouble the court.
Yes.
Beyond that, I was going to look, brief introduction, and look at the factual context of the evidence up to the refusal of asylum first. Then look at the legal and policy framework in the light of the controlling cases with which we're concerned today, and take your lordships through the Secretary of State's decision and the judgments of the tribunals, focusing on whether or not there is material error in the First-Tier Tribunal judgment.
But it's not the question. I mean, we don't really need to go through all the evidence. We're not hearing the case.
You're not
appeal.
Indeed, my lord. I just want to point out because these cases are a question of whether there's a material error. It won't take long, I assure you. But,
no, fine.
Just, so that because each case in these Iranian surplus claims is so fact sensitive, such evidence as there is, it's right that we have it in front of us. But I take my lord's point, and I agree that we're here just to look at the issues. And then after going through the decision and how the First-Tier Tribunal approached it, to make the submissions on grounds 1 and 2. I hope to be done by lunch. That's my ambition. I may slip over, but I
might depend on us.
It will depend on my lords and my lady, of course. It has, and Mr. Toman and I are confident we will have it all tied up, in the afternoon.
Yeah, so good.
So. There is no, but we may make rapid progress on the facts in the light of my lord's indication. My lords, my lady, this is of course a statutory appeal in an asylum case on an appeal from the Upper Tribunal involving a man who is Iranian by nationality and Kurdish by ethnicity. As my lords will have seen, my lady will have seen from the summary of the facts in the grounds. He arrived in the UK in September of 2021 and claimed asylum at that time. His asylum claim was composed of 2 parts. One, a story and an account of why he was at risk of persecution based on his time in Iran. That's not before this court today. He was disbelieved on that aspect of his case, and he and that plays no part in today's proceedings. But there was also what is known in the jargon as a surplus claim based in relation to his activities in the United Kingdom and whether that placed him at risk of persecution if he were to be returned to Iran. So in this case, his credibility in relation to his in-country, his Iranian case was not his case was found to be incredible, and in relation to his surplus claim, it was found that it was not motivated by political concerns. It was essentially contrived. And so the question arises in today's proceedings as to whether that finding, as it bears on the question of whether he would be identified by the Iranian authorities, where that takes us. Where is he in the light of having it being found that he has no political motivation, but nonetheless it's accepted by the Secretary of State and by the tribunals that he did attend demonstrations outside the Iranian embassy in London.
Yes.
And so there are two parts, two grounds to this. Firstly, that he would he. The question for this court is how did the tribunals lawfully reach lawful and sustainable decisions in relation to the question of identification, in the light of the fact that the demonstrations were accepted. And secondly, in terms of what's known as pinch point 2 on return to Iran, was the conclusion sustainable there that he would not be at risk, albeit that his political activities were found to be contrived.
The new phrase, a sustainable decision, what do you mean?
Simply lawful. There's no material error of law, my lord.
You're not saying perversity then, it's they made an error of law. They applied the wrong term.
Yes, in a sense we're saying that the assessment in the application of the country guidance material was materially flawed.
Yes, but why?
Well, I
because they read
hate
the law
to say,
wrong,
my
or
lord.
because they came to a perverse decision. That's what I want to know, is which box.
Well,
Otherwise, you start inviting us to take the decision, which we don't do.
We're not inviting you to take the decision. We're saying it's perverse. It's not it's perverse in the light of the country guidance material. And under the civil procedural rules, an appeal can be brought on the basis of
And is that
law.
for both questions? The decision is unlawful because it was perverse.
Well, yes, in substance, yes.
So both are perversity challenges then.
And we say it's wrong for the purposes of but yes, it's perverse. It has, my lord. Yes, it has. If I appreciate that my lords and my lady have recent experience of these statutory appeals in Iranian surplus claims, but we are focusing on the First-Tier Tribunal's reasoning on the basis that the way in which the Court of Appeal has approached these questions in other cases is to look at the First-Tier Tribunal reasoning. If it's unsustainable, the Upper Tribunal couldn't lawfully conclude that there was no error. So we have authority for that if you need it, but you may be fine as it is. And so, my lords, my lady, I turn straight to the evidence. And
Please.
It won't take us long to look at that, just so that we have it in front of us.
Did he give evidence orally?
He did, yes.
So we're looking at part of the evidence.
We are looking at part
We're
of
just going to look at some of the statements, not the cross-examination record or anything.
Correct, my lord. I'm not suggesting there is any... the findings in terms of what was accepted are in the First-Tier Tribunal judgment, and we will look at that. But my lord is right, that we're not looking at the transcript of the oral
We're looking
testimony.
at part of the evidence, what he put in writing in advance.
Indeed. Just to place what we have in these surplus claims, and when they're on appeal, the question of whether the First-Tier Tribunal erred very fact-sensitive in terms of the task for this court. And so we're simply looking at what there was in this particular case, because they often look very similar, but there may be differences.
I just wonder, if we're only looking at part of the evidence, how is that possibly going to help us? Because we don't know what else was said. That's the only question I ask.
We don't, and if there was a controversy as to what had been added orally, then we would be in difficulty.
Should we just look at it quickly?
My lord, yes.
Yeah.
It has.
Where are you taking us?
So in the supplementary bundle, my lord.
Yes.
And so there is a document. There is a statement. It's at tab 5. If my lord and my lady are working from the hard copies.
Yes.
It's which is a statement that was filed with his statement of evidence form. And so the form you'll find behind tab 6, and the
Right.
But we don't need to turn that up. There's nothing material in it, but the statement is attached to it. And the first line is on page 171, using the pagination on the right-hand side.
Sorry.
At the bottom.
What? Did you say 171?
I did, my lord, yes.
Mine only goes to 113.
In the supplementary.
In the supplementary
bundle,
that
my
is
lord, I
supplementary.
apologise. It's
I haven't. Do you really mean 171?
I do in the.
What are we looking at?
My lord, I have to apologise. It's wrong. My bundle has.
What are we looking at? I thought we were looking at the statement, dated the 13th of January 22.
We were looking behind tab 5, my lord, in the supplementary bundle.
Yes.
I have a, for reasons which are unclear to me, I have a pagination at the bottom there on the statement.
What we're looking at is a statement dated 13th of January 22.
Indeed.
Which is 3 pages.
Indeed, and just paragraph 8 of that. It's one
Paragraph
line.
8 of that. Okay.
Yeah. Just the one line there. It's the first indication of his surplus.
Right. Okay.
And then at the same time, if we turn to tab 3.
Yes.
Following that filing of that statement, there was an email sent, which you will find on page 39 behind tab 3.
Page 39.
Yeah.
Yes, got it.
And that has the picture, the photograph.
It does
very
indeed.
grainy. And I thought my lords, my lady could see that, just because that's often referred to in the judgment.
Yes,
Tribunal
thank
judgment.
you.
And then behind tab 4 is the asylum interview itself, which is a substantive consideration interview that the Secretary of State conducts.
Yes.
And there are, if my lord and my lady turn into that interview, questions on page 51.
Yes.
Questions 26 to 28 about, he's asked if he knows any well-known Iranian people. There's a question about the level of his political awareness. And so he refers to, you can see that I leave my lords and my ladies to read the question and answers there.
Right, thank you.
And then on page 63,
Yes.
at the bottom, from question 100 onwards, he's asked about his surplus activities in the UK. And that turns over onto page 64 and page 65.
Yes.
Grateful, my lord. And then on page 66, finally in the interview, you'll see the final questions, 111 and 112 at the top of the page there.
Yes. Yes.
And then in tab 3 of the same bundle, the post-interview representations made. My lord, those are misdated. It says 21st of March on the 2022 on the date, but it's actually the 21st of August.
Which page?
Sorry, my lord, page 24 of the supplementary bundle at tab 3.
Yes.
And the only part of that which is relevant for our purposes, on page 25, there's a qualification to question 105 in the asylum interview, which we just looked at, which deals with the demonstration that he attended. You can see the recorded answer.
I see. Yes.
And there's a clarification.
Yes, there is.
There.
I'm so sorry, I missed
I'm
the page
sorry, my
reference.
lady.
No, it's my fault, Mr. Berry. Could you just give me
On page 25 of the supplementary bundle,
Thank
behind
you so
tab 3, there's in the middle of the page, there's reproduction of question 105 from the asylum interview.
When he says a clarification, he's not saying it was incorrectly recorded. He wants to add more, does he?
That's correct.
It's additional representation.
It is indeed. It's just
Yeah.
they use the term clarification on the page, but my lord is right. It's additional material.
Yes, thank you.
And grateful. And then before we come to his witness statement, that's made in response to the refusal by the Secretary of State of the protection claim.
So you want us to look at
turn
that?
to that first.
Yes.
Indeed. And that's in the core bundle, behind tab 13,
Yes.
page 110. And it deals with a number of issues. At this point, the Secretary of State did not accept even his nationality,
Yes.
and so there are issues which we don't have to be
Yes.
concerned with. But we pick up, you can see on page 115 in the middle there that it was accepted that at that point he'd only been to one demonstration, that he'd attended a demonstration in London.
Yes.
And then if you turn to page 117 onwards, you'll see the Secretary of State's rehearsal of the answers that he gave in interview. The point I would note is that at the bottom of page 117, his answer in relation to question 105, which was is recorded there, but the post hearing representation letter with what they call a clarification, which my Lord Justice Lewis referred to as rightly as further information, is not recorded there.
Okay.
Was it mentioned in evidence at the hearing? Did you raise it at the hearing before the FTT that there was this clarification?
The material was before the tribunal. I don't
So the
think
tribunal knew about the clarification then.
the tribunal had the material in front of them, my lord. As to whether it was raised, I can't answer my lord's question.
But they had the material.
They had the material in front of them. It would be
Yes.
and say, and then so there is a rehearsal of the material, and then on page 118.
Yes.
Third paragraph down, the Home Office directs itself to its country policy and information note.
Yes.
And then about halfway down to the case of SB, risk on return illegal exit, Iran
Yes.
country guidance case. And concluded that it was unlikely at the top of page 119 that he would be recognised.
Yes.
And that takes us back to, in the evidence, to his witness statement thereafter.
Right.
Which is in the supplementary bundle behind tab 2.
Yes.
And the material, I'm only, of course, taking your lordships and my lady to the surplus material, but on within that statement, on page 19, paragraph 19, in fact, on page 19.
Yes.
Bottom of the page. So this is him explaining, adding material again, as to how he came to understand political activity, how he came to be politically aware, as he put it, in the UK.
Yes.
And I leave my lords and my lady just to read those two paragraphs.
Sorry, 19 and 20?
19 and 20.
Right. Yes, thank you.
Yeah, I'm grateful. And then paragraph 35 and 36 on page 22, he just records his fears.
Yes, thank you.
So, which essentially is he fears harm on being returned to Iran.
Yes.
It's no more complicated than that.
Yes.
And so,
Yes.
so that's the evidence. That's it.
Good.
Apart from the evidence that was heard orally at the hearing,
That's what we
and
have
which
anyway.
is recorded in the tribunal's judgment.
Yep, thank you.
That's the written case.
Thank you.
It has. Then the legal statutory framework is well known to this court. I don't need to go through it, but just for the purposes of my lords and my ladies, note it's set out in our skeleton argument at paragraphs 11 to 18. None of this is controversial to the parties. It's just it's right that you should have the proper framework within which these things fall to be considered. And that can take us straight on to looking at the country guidance case.
Thank you.
The authorities to look at where we are. And the first one I'd like to look at is the...
It would help me, can you just sort of summarise what you say the relevance of the country guidance cases is to your appeal?
Yes, they form the framework within which the tribunal needs to assess the evidence. And if the tribunal has, in the application of the country guidance cases, left matters unconsidered, then we say that the decision is perverse.
So you're saying that if the tribunal has, left what matters unconsidered?
Material issues. Well, I'll develop what we say about the first-tier tribunal judgment in my submissions. But if it hasn't applied the country guidance case to the evidence faithfully in a way that the evidence requires, then we say there is an error. Essentially, it forms the framework. The country guidance cases are a peculiar feature of immigration law.
Are you saying that if there, left material matters referred to in the country guidance cases unconsidered? Is that...
or applies them in a way which is unsustainable on the evidence. There's no issue in this case about the question of what the country guidance, the lawfulness of the country guidance.
I'm not asking that. I was just trying to.
It's the application of it to the facts of the case. The tribunal essentially is assessing the evidence when it reaches a judgment in the light of the controlling country guidance.
Okay.
And so we look at it to understand what the framework is, the parameters within which it has to work, and to see how they discharged that function.
Yes.
I'm grateful. If it assists my Lord at all in looking at this later, in our supplementary skeleton argument, paragraph 3, Roman 2, we set out how the way in which country guidance works on the authority of this court in SG.
Yes, I understand that. Thank you.
Yeah,
yes.
it may just, because it is, obviously it's not a legal precedent at all. It's about setting the parameters where there are similar factual patterns and matters to be considered. And so, my lords, my ladies, BA is at tab 18.
Yes.
And it's a case of some vintage now. It's from 2011. It's the Upper Tribunal, Mr. Justice Cranston presiding, and it has the status of a country guidance case. It has been affirmed as still good law in XX, which we'll come to, which was a later case in 2022. So despite its vintage, it has continuing applicability.
Yes.
And the way in which these country guidance cases work and in which reported cases work is that there is a head note.
Yes.
And it's setting out what this case is concerned with. Is setting out what the framework for how to approach surplus cases, and then thereafter applying it in the case of Iran to people who are demonstrators in Britain, as you can see in the title on page 635, top, and the connected risk on return.
Yes.
But it has a broader application when it's setting the framework for how to think about surplus cases generally, as we'll come on to see. But rather than going through the head note, it's better to see it in the context of how the tribunal reached the conclusions that it did. If my lords and my lady turn to page 638, paragraph 4. You'll see that in this case it's the same position with a surplus claim that there are demonstrations outside the Iranian embassy in London. There are 5 demonstrations. The appellant in this case featured briefly for 2 to 3 seconds in a video clip of demonstrations chanting anti-regime slogans, which was then uploaded onto YouTube. And his photograph also appeared in a magazine, which was an anti-Iranian regime publication.
Yes.
And then at paragraph 7, that it was held at first instance that the appellant had deliberately and opportunistically attempted to establish a claim as a refugee surplus on the basis of his...
Yes.
And then from paragraph 15 onwards...
Do we need to read 8, the findings about the extent to which they were trying to identify him?
Yes. Apologies, by the way.
Okay.
Yes.
And the developments in Iran after June 2009 are considered from paragraph 15 onwards. And then a situation outside of Iran from paragraph 26 onwards.
Yes.
And at the bottom of page 645, you'll see at paragraph 29 there that this context of surplus claims, where people are protesting outside the Iranian embassy, arises in the context of the efforts of the Iranian regime to target people in its diaspora. And so you can see there is evidence that's referred to from the Wall Street Journal about tracking individuals across social media.
This is the background evidence that they're summarising.
Indeed, yes. And also including identifying them at the bottom of paragraph 29 there, at opposition protests abroad. And then if my lords and my lady turn to page 646 at paragraph 30, the evidence of more direct surveillance of Iranian protests abroad. And as I'm sure the court is aware, the UK Border Agency was an iteration of the Home Office at that time with responsibility for immigration and border control.
Yes.
And so, and you can see there the assessment of the Metropolitan Police Officer in paragraph 30, who had been patrolling the demonstrations. There's filming going on at the demonstrations, and his view was that any intelligent person would assume they're sending the footage back to Iran.
So that's background evidence of the times they were quoting a Metropolitan Police Officer. So that's what we've got from that.
Yes.
In 2009.
Yes. It's and then if then turning over to page 648 and paragraph 41.
Yes.
That this is about, if you like, pinch point 2 on return to Tehran, that other sources suggest that there are photographs kept at the airport of those protesting abroad. And then there is a reference to a report by the International Campaign for Human Rights in Iran, which is an NGO comprising of people of Iranian origin. And the extract from their report is what you find at the bottom of that page.
Yes.
And the point about that, my lord, is that in that extract, joining the dots between filming protests in the United Kingdom and then what happens on return, is a suggestion is in that report that when flights come in from particular places, the photographs from the relevant cities concerned, looking at the top of page 649, are scrutinised to see if anyone matches.
Yes.
So there is some evidence at that point, back then, of that situation. And then if my lords and my lady turn to page 650, you'll see the legal principles section that were to be applied. And this is, it's the same test in relation to surplus activity. That activity, even where opportunistic, is not an automatic bar to a claim. One simply applies the usual commonly understood refugee protection test. Is there a reasonable degree of likelihood of risk? Assessing the evidence on the same basis. Using the same standard, which is not news to this course, of course. So that's the legal principles as they were applied there. And turning over to the party submissions, begin at the top of page 653. But for our purposes, I'd like to take my lords and my lady just to paragraph 62 on page 654, which deals with it's not the United Kingdom Border Agency, or effectively the Home Office, who provides the flight manifests to to Tehran. It's the airline staff that do it. In terms of the names of the people who are on the flight. But that information is provided, it's just not a suit of the Home Office.
Yes.
And then the conclusions of the Upper Tribunal begin on page 655, and these are the paragraphs of substance which lead to the head note in the judgment. But we've reached the point where we've seen the evidence, or the extracts of the evidence on which the tribunal was looking at to form this conclusion. And you'll see that paragraphs. So the paragraphs of which I'm taking you through are paragraphs 64 to 67, which are the critical ones. So the back cloth is set out at paragraph 64 that there's an announced intention to proceed against dissident Iranians abroad. That's of the Iranian authorities to proceed against. And then what the tribunal is doing in paragraph 64 is developing a framework for how to look at surplus claims. And it includes a number of things which are material to this judgment and the First-Tier Tribunal judgment, and the way that the tribunal went about its business in assessing the risk of identification.
Yes.
And my lord will say at the four broad overarching categories, the first of which is the nature of the surplus activities. And the various, but I won't read them all out because my lords and my lady, it would take too long. You can see them in context. But just to highlight, all of them are important, but just to highlight those of particular salience to this case. Well, there is the theme of demonstrations, but after that, the role that a person plays in their political profile. Can that person be described as a leader or a mobiliser, an organiser, or simply a member of the crowd? And just pausing there for a moment, my lord, if my lord has that, the second bullet,
Yes.
If one is simply a member of the crowd, that's further subdivided into are you active or passive? Are you sort of carrying a banner or somehow other? So you can be an ordinary member of the crowd and still have, if you like, an aggravating factor, which is you're doing something, you're just not a leader or an organizer,
Yes.
or the like. And then the bullet below that, extent of participation, and this is something we do place reliance on. Has the person attended one or two demonstrations, or is he a regular participant? And just to note for my lords and my lady that's the framework. Is it one or two demonstrations, or is there a regular pattern? It's not more complicated than that. It's very short, and it's a very...
Well, I think all that is saying, as it says in the first three words, is the extent of participation.
Indeed. And
that's what you have to consider,
and
the extent of participation.
It's not setting a bright line, clearly. But the qualifier is really, it's just an indication of how to start to think about what extent of participation is. But it's certainly not setting a rule, of course. But it's all of these are factors. I mean, as the final sentence in the control, if you like, the paragraph of which this is a list, the chapeau, the factors are not exhaustive and may overlap. These are evaluative. It's a framework, a way of thinking about surplus evidence.
But Mr. Berry isn't that exactly what the FTT did in its determination? It was seems to me, provisionally at any rate, it was a very careful consideration of the precise nature of this appellant's field class activities.
My lady, it did purport to apply them, and I hope to show you...
It did purport to apply them?
It did apply them. My lady, sorry, I correct myself. It applied them. We will make criticisms of how it did so when I come to it.
But if it directed itself in accordance with the country guidance clause, how it went about applying the country guidance to the facts is a matter for it, isn't it?
Ordinarily, unless it steps outside the bounds of
right, so you're going to show
got to be perverse, hasn't it? That's what I was asking
you're
you.
going to show
my lord,
the FTT's consideration of this particular issue was perverse.
We are going to show that the way it applied these is unsustainable. Yes, it has.
But it's a very high test.
Yes.
You've got to show us that no reasonable FTT, faced with this evidence, could have reached the conclusion which this FTT reached. And at the moment, I mean, no doubt you'll devote your argument, but at the moment I'm struggling to see it.
Grateful for the indication. I hope to persuade you when
what I worry about is you're taking us through bits of the evidence, not all of it, bits of this, and you're going to invite us to reach a conclusion. But that's the wrong starting point. That's been done twice. What we are going to do is look at the judgment, and you will say that bit of the guidance was never even referred to, or
I just need to show you the country.
Okay,
so that when we read the judgment, we have it all right at the forefront of our minds. It's not a. I do appreciate my Lord's point about the specific job that this court may or may not do in the context of two bites.
Okay.
The First-Tier Tribunal assesses facts.
Are there which particular elements of the list in 64?
Yes, my Lord. So those bullet points, which I've just referred my lords and my lady to, then the identification risk at the bottom of that page,
yes,
which includes through filming them, as you see in the final line, and then at the top of page 656, the regime's capacity. Remember that this framework is for all surplus cases, so it's not. It's setting the regime's capacity to identify individuals. Does it have advanced technology?
Yes.
And then factors triggering an inquiry on return includes the second bullet point, the immigration history, the way in which one left, and essentially, if you left illegally and you're undocumented, you will. Those are aggravating factors that may lead to you being could lead to you being identified.
Yes.
And then, as my lords and my lady can see, consequences of identification are listed, and then identification risk on return. So that's the framework that the tribunal sets for how surplus cases generally are to be considered.
I understand that. But if you then go on and look at the analysis in 65, 66, It's quite condensed.
It is.
It doesn't go through all the factors listed above. It takes what the Upper Tribunal in that case considered to be the critical factors and analysed them and came to a conclusion.
My Lord, yes, because absolutely. The 64 is setting the framework for how to think about surplus cases generally.
But it doesn't say you need to consider every factor in every case.
No, not at all.
Right.
And 65 is applying it to Iran. So 64 is a general framework for how to think about, without prejudice to how it applies to Iran. And then 65 is the application of it.
And the core of the decision is in one paragraph, paragraph 69. We consider there are a number of factors would be used to.
Applying it.
Particular place weight on the fact that the face is clearly recognisable in the photographs in a publication, and then reach a conclusion as to the level of risk. But it's quite it's quite a narrow analysis. Right. Okay.
It is, my Lord, yes. So 69 is applying it to the individual.
Quite.
65 is setting out how the surplus criteria are reflected in what's actually going on in relation to Iran, which is then applied to the individual decision.
Yes.
If I could just take my lords and my lady to 65, it's fact. So the second line of 65, we're persuaded that the Iranian authorities attempt to identify persons participating in demonstrations outside the Iranian embassy in London. The practice of filming demonstrations supports that. The evidence suggests that there may well have been persons in the crowd to assist in the process. So that's the reason this is country guidance. It's not just about the appellant. It's looking at the general position.
Yes.
And then, of course, facial recognition technology there is insufficient evidence for that. Picking up halfway through the paragraph, we believe that the information gathered here is available in Iran. While it may well be that an appellant's participation in demonstrations is opportunistic, the evidence suggests that this is not likely to be a major influence on the perception of the regime. In other words, that does not something that not likely to move them when they think about the nature of the person concerned. Although expressing dissent itself will be sufficient to result in a person having, in the eyes of the regime, a significant political profile, we consider that the nature of the level of the surplus activity will clearly heighten the determination of the Iranian authorities to identify the demonstrator while in Britain and to identify him on return. And that, combined with the factors which might trigger inquiry, would lead to an increased likelihood of questioning and of ill treatment. So the point I'd like to emphasise here is this is about the filming of the demonstrations and about the spotters in the crowd. It's not about the use of social media. It's not about Facebook material. This is about evidence which the Iranian authorities gather for themselves.
Yes, but it's also about the matters about his participation in the demonstrations which would make the regime likely to want to identify him, and those are referred to in paragraph 69.
They are indeed in the application to the individual in question, of course.
You've also got to read 66. 65 says, how likely are they to get the photographs in England? 66, what's going to happen to them? Will they be identified? And if you look at the last sentence, we conclude that for the infrequent demonstrator who plays no particular role in demonstrations and whose participation is not highlighted in the media, there's not a real risk of identification and not a real risk of consequential treatment. And you go on to 69, and this chap was on the YouTube, which we've all heard of. He was on a publication. The publication was particularly inflammatory, and so on. So, it's very dangerous to take sentences out of context without reading the whole thing and bearing in mind
it is
facts of the case.
It is indeed, my lord, and I wouldn't wish to do so. I was taking my lords and my lady through 65, and then I was to progress on through.
Okay.
But the reason 65 matters is although this is building up to an individual's assessment and the individual who was on the facts of this case at risk. And what's happening at 65, it's the application of the general criteria to the position of Iran, and then it goes on to apply it to the individual in question. And my Lord Justice Lewis rightly takes us to paragraph 66, because you must read that in its situ, in context, because the first part of it says that as regards identification of risk back in Iran, it would appear that the ability of the Iranian regime to identify all returnees who have attended demonstrations, particularly given the number of those who do on return, remains limited by the lack of facial recognition technology and the haphazard nature of the checks at the airport. So it's not comprehensive. It's not everybody,
No.
all returnees, but it is some.
Yes.
Yes. And I make the point at this point that there is a risk of it. If there are some people who will be identified, then there is a risk of
But you really have to read the last sentence. The one group where they are saying there's not likely to be a risk or not a risk, and I don't pick me up on the words, it's
No.
is those who played no particular role in demonstrators whose participation was not highlighted in the media. So, it's not saying there's a risk. Anybody could be in the risk. They're saying it's difficult to work out. There's going to be a risk for some. We know that for one group, there's not a risk.
Yes.
Not even a real risk.
Whatever the phrase you use, yes.
Yes, and I have to confront that paragraph.
Yes.
Does it follow? And that's the final sentences of that paragraph. What it flows on from is that there is some surveillance. There is a haphazard nature of checks on return. There isn't comprehensive surveillance. Some people may be identified, but not all, because they don't have facial recognition technology. So the beginning of paragraph 66 is dealt with. It is setting the scene, is that there isn't comprehensive facial recognition technology. Not all returnees there isn't the ability to identify all returnees who have attended demonstrations. That's what the first sentence says of paragraph 66. And what we get from the paragraph we conclude, therefore, is in my respectful submission to the tribunal. It doesn't follow from the fact that some people may be at risk. The way that they draw this conclusion for the infrequent demonstrator who plays no particular role in demonstrations and whose participation is not highlighted in the media, there's not even a real risk, as my lord rightly identified, of identification. That analysis doesn't follow from the former. If some people are at risk of identification...
Sorry, you're now questioning the validity of the last sentence.
I'm simply saying that the conclusion doesn't follow from the beginning.
But it's a country guidance case.
It is a country guidance case for the framework of it, but the weight in which one, it's not the weight which one, the approach to the reasoning in it, on this issue, I'm merely identifying that the way in which it draws the conclusion that there is no risk for infrequent demonstrators doesn't follow necessarily from the proposition.
So are you saying that it's not that he misapplied the guidance by applying it, he went wrong in law by applying it and not realising its flaws?
Well, there are two aspects to it, my lord. Firstly, that the tribunal has in mind, what constitutes infrequency is one or two demonstrations all regular. That's the way it looks at the framework at paragraph 64. But the second part of it is that it is our submission that the framework at paragraph 64 is a way for a first instance tribunal to organise its analysis of the evidence. It's not a checklist, for example, that all of these features have to be present or some of them have to be present. It's a way of building a structured approach to analysing the evidence to see if identification is an issue and if so, is there risk on return.
But I thought your argument was that the FTT went wrong by not applying the country guidance. You now seem to be saying that the FTT went wrong by applying the country guidance too literally. So what's the submission?
The submission, my lady, is simply in relation to paragraph 66, that there is a note of, it's not a strikeout for all people. It's that paragraph that we conclude. It's the task of the First-Tier Tribunal is to assess using the rubric, the framework at paragraph 64. The conclusion there is plain in general terms, but it falls to be applied in an individual case, depending on the issues. That's
what the FTT did. They said his attendance at these demonstrations has been sporadic. It coincides with key moments in his claim, and he's not a particularly prominent person. Therefore, not at real risk of identification. What's wrong with that?
Well, my lady, we take issue with the tribunal's conclusion that his attendance was sporadic, and as if it were infrequent. There were
That's an assessment for the FTT, surely.
The question, what the FTT concluded was that he attended he attended 6 demonstrations across a period of time.
Is that factually correct?
Well, he says it was. There were more demonstrations.
That's what they found.
That's what they found as a fact. Yes.
And they didn't say sporadic. They said 6, and they've attached that as a descriptor.
And they have indeed. Yes, they've attached it. And when I say that descriptor couldn't be attached to the. If we look at when we come on to look at the judgment and we look at the frequency of the demonstrations, which is down to the date of the hearing.
Can we just go back? You're taking us through the country guide.
Yes, my lord. Yes.
I appreciate that we're asking you questions about how to.
No.
But can we just finish going through the country guidance?
Indeed.
And then we'll come to the
Determination.
yeah.
So my lords have paragraph 66.
Yes, we do. And we read 69.
And 69. Yes.
Yep.
And so I can finish with BA.
Thank you.
In relation to that.
Yes.
And then we have at tab 12 the case of HB. And this is a further country guidance case at page 353. This time from 2018 with 2 distinguished Upper Tribunal judges. And this deals.
What do we get from this?
This is about, well, first of all, it's surveying the factors which apply, as you'll see from the head note. And it's something that the tribunal applies itself in relation to Kurds generally. So it's going through where are we with the position of Kurdish Iranians at this point. And you can see, I mean, it is as easy as anything simply to read from the head note on this particular case.
Okay.
But you'll see there that the first paragraph referring to SSH and HR
Yes.
in respecting to there's no risk for refused Kurdish asylum seekers on account of their ethnicity alone.
Yes.
Paragraph 1, there is discrimination. Paragraph 2. Paragraph 3 at the top of page 354. That from 2016 onwards, the Iranian authorities have become increasingly suspicious of and sensitive to Kurdish political activity. But notwithstanding that, paragraph 4, the mere fact of being a returnee of Kurdish ethnicity with or without a valid passport, and even if combined with a legal exit, does not create a risk of Article 3 treatment. And then paragraph 5, which is of importance, Kurdish ethnicity is nevertheless a risk factor which, when combined with other factors, may create a real risk of persecution or Article 3 treatment. And then the other factors will include the matters set out at 6 to 9 here, including at 6 a period of residence in the Kurdish autonomous area. And then paragraph 7, Kurds involved in political groups or activity are at risk of arrest, prolonged detention, physical abuse. Even Kurds expressing peaceful dissent or who speak out about Kurdish rights also face a real risk of persecution. And then at 8, activities that can be perceived to be political by the Iranian authorities include social welfare and charitable activities on behalf of Kurds. And then, indeed, involvement with any organised activity on behalf of or in support of Kurds can be perceived as political and thus involve a risk of adverse attention by the Iranian authorities with a consequent risk of persecution. And then at 9, even low-level political activity or activity that is perceived to be political, such as, by way of example, only mere possession of leaflets, espousing or supporting Kurdish rights if discovered, involves the same risk of persecution or Article 3 or treatment. Each case, however, depends on its own facts, and an assessment will need to be made as to the nature of the material possessed and how it would be likely to be viewed by the Iranian authorities in the context of foregoing guidance. And then
Yes.
at 10, the Iranian authorities demonstrate what could be described as a hair trigger approach to those suspected of or perceived to be involved in Kurdish political activities or support for Kurdish rights. By hair trigger, it means that the threshold for suspicion is low and the reaction of the authorities is reasonably likely to be extreme.
Yes.
And so, and that is, and my lords and my lady can see from within that judgment that there was consideration in assessing those factors. At page 361, you can see that BA, the case we just looked at, was considered and re-examined by the tribunal.
Is there anything in this judgment which, when it's dealing with points 5 combined with other factors, 7, 8, 9 and 10, that deal specifically with attendance at embassies and protests? Or does it not specifically address that?
Well, it's just that this 9, for example, my lords, it doesn't specifically address that.
So it doesn't say the activities include or the activities do not include attendance at demonstrations. It just doesn't deal with it in that level of specificity.
It doesn't address that issue, but it's building on BA already. Because so the reason I took my lord to page 361 is that's in front of them, squarely in front of them, and BA, of course, deals with surplus demonstrations.
So which bit actually helps us on the facts of this case, then?
Because it's the framework, including at 6 to 9, is what falls to be applied by the First-Tier Tribunal when they look at.
Well, there might be something other than being Kurdish which will draw them to the attention of the person concerned. And we know that speaking out and activities that are charitable on behalf of Kurds, but
yes,
I haven't read this before, and there are 67 pages of it. If it doesn't, or if it does say something about and activities which include demonstrations at an embassy are to be taken into account in the following way, to be helpful to know that rather than have to read 67 pages.
No, but my lords, I would spare you the burden of that because there isn't.
Okay.
What there is it's sort of the placeholder is at 361, the reference to BA, because that does deal with it. So they don't re-interrogate that.
They don't go any further.
It's assimilated as part of the sorts of things that fall under paragraph 9, effectively the political activity question. This is a survey, if I can call it a survey country guidance case. It's simply that it's going through a number of related issues in relation to.
Well, that's interesting. In paragraph 21, the Upper Tribunal says that the decision A, B and others is categorically not country guidance.
AB, yes, not B.
Does not have that designation. However, it is a reported case in terms of the evidence that was before the tribunal, and both parties referred to it in that context. It is appropriate to include it in this section, although noting it is not country guidance.
Yes, my lady, that's AB, which is a different case to BA.
Oh, it's not B. I'm sorry,
Yes, apologise.
I've got the initials back from.
Yes, no.
Okay, so that's irrelevant.
No.
Ignore my question.
No, not at all. It's
Right.
Could you just take us to the passage that does deal with activities in the 67 pages that discusses activities?
Well, there is an expert.
No, the conclusions. Well, I don't want to go through the evidence. I'm not interested in the evidence. I want to know what conclusions, if any, they gave where they discuss activities.
Page 379. And paragraphs 92 to 95, my lord.
That's 377 is headed conclusions. And which paragraph?
Sorry, mate. Page 379, and the sidelined paragraphs there. Particularly
We need to begin it before, don't we? Is it
part
9?
So the expert evidence is from a Miss Eniat, whose expert report reference begins to be, and there are other. The expert evidence evaluation begins from 370 at paragraph 42.
But the conclusion on this really is
The
from
conclusions are on this
88
page.
onwards. Paragraph 88
yes,
onwards.
indeed, my lord.
And she's dealing with activities being involved in Kurdish political groups, social welfare and charitable activities.
Indeed.
And what emerges from that is the sensitivity on the part of the Iranian state. So even if you've got a Kurdish flag or a leaflet, presumably of the sort that you just described, doesn't at the moment appear to be thinking about people who attend and are in the crowd at a demonstration. It doesn't seem to be dealing with that.
It doesn't deal with it in terms, my lord, partly because the authority of BA is cited, in question, is deployed here, and then they move on.
But that would mean that BA would be the test unless they added something specific.
Indeed, yeah.
In which case, this doesn't help us.
The only help we get is that the framework in the head note is routinely applied to look at the position of assessing risk of identification on the basis of activities.
Thank you.
My lord, just while we're on that authority, so I don't have to go back to it, one paragraph that I've highlighted as potentially of use to the appellants is paragraph 85, where there's a concession made by the Secretary of State about the degree of questioning on return that may flow from being a Kurdish enemy.
Very grateful to my learned friend.
Paragraph 85.
This seems to be about somebody coming from Iraq.
It is. That's about the KRI, which is the province, the Kurdish autonomous area in northern Iraq.
Is it relevant to this case?
In this sense, that I accept that this authority takes us further insofar as it suggests that you are likely to be questioned on return if you return as a Kurdish individual, and that questioning may be more intense if you have specific characteristics. One of them, I accept, is being Kurd, and another one is having lived in the KRI, which, as my lordships and my lady will know, is the Kurdish autonomous region of Iraq.
Yeah, thank you. Yes, right. So that's HB.
That's HB, and then XX, which is at tab 7 of the authorities bundle. This is another country guidance case from the Upper Tribunal with Mr. Justice Laing presiding. And this we can be brief with because it concerns, the main part of it is concerned with social media and the use of social media.
Right,
But,
yes.
But what it also does, among other things, as you'll see from the head note at the top of page 146, and this is obviously a judgment from 2022, is it confirms the continuing relevance of BA and HB, the two cases which we've just looked at.
Right, okay.
And the issue in this case, what XX moved the position on for users of social media about whether they could be reasonably expected to close their social media accounts before being returned to Iran. And the
Yes.
well, there's just one paragraph I would take your lord, my lords and my lady to, which is at paragraph 118 on page 180.
Yes.
And there that dealt with, it was sort of, in a sense, it slightly merged the two questions of attendance of attendance at events, and the question of whether and the use of social media.
Well, what's the reference to prominence of the person you secured a photograph with? What's that all about? Because it seems to be a medley of factors.
It is, and I don't, I just merely cite it because it does sort of have a medley of factors. The focus of this case is, and Mr. Thurman was in this case, is on the use of social media. It's just that it assimilates this question of, if you like, what you might call real-world participation in events into their use, mobilization on social media. I wouldn't want to miss a reference to real-world events, but I don't think it adds.
The impression I get is he made sure that he was in a photograph with somebody the Iranians were interested in. So, you know, if it's the leader of the opposition party with down with the regime thing, and you're standing right next to him with his arm around you, they might notice you as well. Seems to be putting it in paragraph what they're saying. So that's what they're saying there, is it?
Yes.
Right. Okay.
Yes, I think that's in a nutshell. Yes.
Right. Okay.
And then so those are the major country guidance cases. There are then the decisions of this court, which are well known to this court, this composition particularly, in relation, and I'm conscious that particularly FA Iran, which is at tab 3, which my lady gave principal judgment is an example of a case where, notwithstanding that there is respect paid to the First-Tier Tribunal as the finder of facts and doing the assessment of whether or not international protection obligations are engaged. Nonetheless, is an example of a case where this court nonetheless sent the matter back to the First-Tier Tribunal because of the confused nature of the First-Tier Tribunal's findings. And I'm not for a second suggesting cases are ad idem. I'm just giving it as an example of, if you like, one end of the spectrum where notwithstanding that this court is supervising at 2 stages of remove the First-Tier Tribunal's position on what it did, it is possible in a case where that a person had attended a demonstration and then a meeting and then had also used social media for the First-Tier Tribunal judgment nonetheless to be insufficiently reasoned that it can be regarded as unreliable, sent back, missing key findings.
And 59 is interesting. In rather forthright terms, Her Ladyship said it's difficult to interpret, if not unintelligible. The last sentence was all but meaningless. So that seems to be that case. I mean,
well, my lord,
I don't see what help we're getting from this. Are you just saying just because there's 2 people looked at it doesn't necessarily mean it's all right? There may be some problem with it.
Not at all. I would put this case at one end of the spectrum where it's obviously can't stand, and then there are the current case may be not as bad as this, but it may still nonetheless have flaws. It has that render it perverse. I'm not, but the supervision, if you like, of this court can nonetheless be engaged, and therefore, and say, and my latest conclusions and the discussion at paragraph 66 and 67 on page 44 deal with the application. My Lord, Lord Justice Lewis asked the question about what relevance HB has and the criteria there to a demonstration case, and there is an example there of its application to cases of demonstration on a surplus basis. That framework in the head note of HB is applied in this context, and then the opacity of the conclusions of the First-Tier Tribunal are then set out in paragraph.
Well, in short, the reason this court intervened was because there were no clear findings about what an investigation of the Facebook account would show, para 70, and in the light of the limited findings, its conclusion there would be an issue for the appellant on return, but that it would not elicit the authorities' hair-trigger reaction is inexplicable.
Oh.
That's why we sent it back.
Yeah, my lady, yes.
So that's quite a high bar, isn't it?
It's just as this court dealt with a similar issue, I draw it to the court's attention to show that there is an example of a situation where First-Tier Tribunal judges, notwithstanding the respect and the expertise of the First-Tier Tribunal in assessing these matters,
Well, they can occasionally get it round their neck, but I don't see how that decision helps you in this case.
My lady, I just didn't want to overlook a judgment of this court appearing with this composition of this court that was on point in dealing with a surplus claim. I don't think there is an extract from this. It's an example of where it went wrong and it was recognised.
Okay, thank you. So that's FA. What next?
And then the same pair of goggles on, perhaps, and digging myself in further. Tab 4, S against the Secretary of State. For the claimed part.
I know what we said, that they said expectantly to. Oh, the Lord Justice Jeremy Bacon wasn't there. The judge, although we must have agreed, yes.
So,
yes, okay.
So, obviously, for December 2024, but dealing with, in this case, of course, the judge's reason in a surplus case, again, was found to be sustainable, and like in FA. And the facts, as you, my lords will be aware, for my lady as well, at paragraph 7 of the judgment on page 48.
Yes.
In related to, you can see demonstrations. And in that case, there he was standing alone at a significant distance away from the embassy, behind a hedge. And moreover, his Facebook account, which had been set up by a third party on an unknown date, had ceased about 2 months or so prior to the interview.
Yes.
So the only point I would stress there is he was obviously remote from the embassy demonstration.
Yes.
Behind a hedge is pretty...
You started your submissions by saying they're fact-sensitive claims.
They are,
and
yes.
I think that's what this analysis of the authorities brings out, is that they are fact-sensitive claims.
Indeed. And if I'm not on the hunt for legal precedent, it's just that as this court has on 3 occasions recently looked at surplus Iranian claims, it would be remiss of me not to draw the court's attention
No,
to
thank you. Yes.
And then at paragraph 12, there are further demonstrations which he attends. And then at paragraph 14, consideration of the case of BA, which we've looked at. This is the First-Tier Tribunal judge that's being reviewed.
Yes.
The judge reminded herself. And then you see the holding at paragraph 15 in this case, which is the one that then gets put before the court, that there was no suggestion that demonstrations had attracted media attention, an infrequent demonstrator, no particular role, just a face in the crowd.
Yep.
Not reasonably likely that the appellant was a demonstrator who the Iranian authorities would wish to identify. And then at paragraph 20, the first, again, dealing still with the First-Tier Tribunal judge, the appellant's political activities, the judge found, were opportunistic and not genuine. He would like to close his Facebook account. And then paragraph 25, permission to appeal to the Upper Tribunal from the First Instance Tribunal was given solely on consideration of what we might call the pinch point 2 issue, the risk on return.
Yes.
And what he could reasonably be expected to say to the authorities on return. And we get that from paragraph 26. And the
Ground of appeal at 35. It's not unlike one of your grounds of appeal.
No,
To consider material matters as per the Iranian country guidance cases, including the increased likelihood of the appellant's attendance at demonstrations being brought to the attention of the authorities.
That's correct.
And did that succeed?
It did not on the fact-sensitive nature of this case. No, it didn't. But each person has their own life to lead, and this appellant has the question before this court is really whether the treatment of the First-Tier Tribunal in this case is sustainable, perverse, and whether or not. But on this case, no, it didn't. And the discussion begins from paragraph 37 onwards, and noting and noting the applicability of the criterion BA, looking at paragraph 40 onwards on page 59, the appellant had sought to rely on paragraph 65 of BA, and of course the court went on to look at the other paragraphs in that judgment, which we've already looked at, paragraph 66, 67, and my Lord Justice Moylan pointed out paragraph 69 as well, making an individual assessment in this case. And then what had happened in this case, as I read it, is that both tribunals below hadn't made express findings on the risk on return on pinch point 2 issue. And so the question was, what could be done in that context? Were there sufficient findings of fact arising out of the findings made in respect to the prior question of which they identified that one could infer what the tribunals, particularly the First-Tier Tribunal, would have done had it directed its mind to that question. So we see the approach taken from paragraph 48 onwards.
Yes.
And the question the Upper Tribunal judge was entitled to find that the United Kingdom activities did not disclose risk, in a nutshell, and then a rehearsal of the material, including being 49, being photographed at a distance away from the embassy. And then in paragraph, then the question moves on to this question of risk on return, picking up from paragraph 51, the second ground. The court turns to the second ground which is, just for purposes of my lords and my ladies' note, the second ground is set out page 58 at the top at Roman 2. So that's what the court is turning its mind to.
Yes.
At that point, and going through that, paragraph 54, you can see that the court's scrutinising the first instance tribunal judge here. Regardless of this, it's apparent that the judge accepted that as the appellant was of Kurdish ethnicity, he'd be likely to be questioned on entry into Iran. Hence the question which she posed, namely what the appellant would or could reasonably be expected to say when questioned by the Iranian authorities.
Bearing in mind that they're opportunistic and not genuine,
yes,
was entitled to find that the appellant would not be required to volunteer information about those activities.
Indeed. And then,
I mean, 55, the counsel said, oh, well, that would be a lie. And the answer was it wouldn't be a lie because he wasn't a supporting demonstration. He was just there to try and get his picture taken for his asylum claim, reading what Lord Justice Jeremy Baker says.
Yes, indeed. So in that case, what happens is that looking at the way in which there was no material error in the assessment by the First-Tier Tribunal in that case.
Yes.
I think in fact it's an assessment by the Upper Tribunal because I think the Upper Tribunal was remaking.
They did remake.
Remaking an FT decision with some retained findings.
Yes, indeed. So, and so there was so that.
Thank you.
That's
that one.
And then the final case from this court is at tab 1, which is the OM case, principal judgment from Lord Justice Yurt.
Yes.
And again, as you see from paragraph 1 and 2 on page 4. It's a surplus claim from an Iranian asylum seeker, and his activities after he left Iran were considered to be contrived for the purposes of his claim for protection. And then you see, and as we're clear, as is clear, paragraph 2, the assessment of risk on return, faced on return to Iran is fact sensitive. And then, based on the First-Tier Tribunal findings, case was dismissed.
And in that case, it attended 17 demonstrations.
Yes, exactly, my lord. At the bottom of page 4.
But the tribunal was not satisfied. The attendance would have come to the attention of the Iranian authorities or attracted publicity.
Top of page 5, my lord.
Yeah.
Yes, it has indeed. And so
screenshots, Facebook. Yes.
Yeah, yes, and a lot of these cases involve both surplus demonstrations and then the use of social media.
Yes.
Say that. And then Roman 10 on page 5, halfway down, the Facebook thing, activity was also contrived on the facts of that case. And you can see there at paragraph 8 that the judge made reference to authorities which we have looked at, XX and HB,
Yes.
in relation to that. XX, of course, refreshing both HB and BA as of continuing relevance in that case. And then at paragraph 15, that the appellant had appealed to the Upper Tribunal against the dismissal of his claim, and the sole ground that remained relevant for the purposes of this appeal, meaning before this court, was that the First-Tier Tribunal failed to properly assess risk having regard to the hair trigger approach that might be elicited by the Iranian authorities from the appellant's surplus activities. And then at paragraph 16, the appellant had argued that he could not be expected to lie about his United Kingdom opportunistic activities. And then, my lords and my lady, can see how the appellant's appeal to this court progressed, paragraph 21 onwards. So the appellant's contention was that paragraph 21, the Upper Tribunal erred in concluding that had the First-Tier Tribunal properly applied the hair trigger guidance, the outcome would have been the same. And you can see how his case at paragraph 22, the appellant contends that he's likely to be questioned on his return to Iran based on his Kurdish ethnicity alone. Therefore, the vital question not addressed by the judge at first instance was what he would say about his political activities, irrespective of whether they were genuine or not, even if he had deleted his Facebook.
That was the submission, and it was firmly rejected.
It was. And I simply draw my lord's attention to what was rejected.
At 51, so it's fact specific, but all the facts look awfully similar to what you're saying here. And at 51, it was found not to be a good ground of appeal. It was only if the authorities suspected S's involvement in political activity or support for Kurdish rights that he would be at risk. They concluded that he wouldn't have to volunteer information about his activities were not an expression of generally held beliefs and which were contrived. And the Court of Appeal accepted that the judge was entitled to make findings of fact. It's summarising FA, is it? Yeah. So what did it actually decide in this case? Well, it doesn't help us, with the greatest respect, to take us to what people have said the law should be. The question is what this decided. So what did it decide?
Well, it
from
decided
52 onwards.
Yes, indeed. It decided that there was. I only drew my lord's attention to the submission in order to show what was rejected when things were decided. It was how the case was put for purposes of completeness, so that one could understand the way in which the court approached this. And what the court did at paragraph 52, as my lord rightly draws attention to the adjudication of what was decided, was that it decided that neither the First-Tier Tribunal nor the Upper Tribunal really addressed the question of what would happen at the second pinch point of return on Iran. So there was a gap in the reasoning, of both levels of the tribunal. And had it done so, given the findings that were made, they then would have approached it on the basis that. So this court fills in what were the gaps from the First-Tier Tribunal and the Upper Tribunal in doing this. But there was a gap in the reasoning. And so, in a sense, it's what this court did about it, that the remaining paragraphs.
Well, it was the inference that you draw from the findings of fact. It's 56 and 57. It's difficult to see that assists you.
But my lord, we would seek, if we sustain our case today, we would seek, rather than for inferences to be drawn on the second question on return, a pinch point on return, for the matter simply to be sent back to the First-Tier Tribunal.
They're not saying there's a gap. You're misrepresenting the decision. This was saying that the judge made certain findings, and the natural inference from those findings was that contrived activities didn't have to be drawn to the attention of the Iranian authorities, and the attendance at the demonstrations wouldn't have come to their attention, and therefore there was no error of law in finding that he would not be at risk on return. That's what this is saying. This isn't saying where there's a gap, there's an error of law, and you've got two choices, remit or infer. That's not at all what they're saying.
It's not what it's saying. My lord's right about that. It's saying that paragraph 52 that the matters weren't clearly addressed about pinch point 2 on return, and then the court takes what it can from the judgment on the findings that were found.
Well, the court's analysis is that gap is not a material error of law, because on the basis of the findings that were made, it's absolutely obvious that the hair trigger response would not be elicited. Isn't that their analysis?
My lady, what it says, yes, in paragraph 57, midway through, it says, on the express findings made by the judge, it can properly be inferred that the appellant would not be expected to volunteer information about his contrived activities in the UK when questioned on arrival in Iran.
If you go back to paragraph 56,
yes,
Lady Justice Yip says in terms there was no material error of law in the findings of Judge Power. The absence of explicit reference to hair trigger approach, blah, 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 does not represent any material error.
Indeed, in her, my lady's judgment in that case, she finds the fact that the question wasn't clearly addressed not to be material. Yes, indeed.
I'm not entirely clear how this case helps you.
I'm not suggesting that it is of great assistance to me. I'm suggesting that it's just simply drawing my lord's and my lady's attention to the fact that it is authority of this court on similar case.
Thank you.
And it's right that I put it in front of you so that you understand the terrain.
So that is the end of the authorities?
That's the end of the
Thank you.
authorities.
Can I make a slightly carping comment about the authorities bundle, please? It's much more helpful to us if the authorities are arranged in chronological order rather than reverse chronological order.
I will take that.
Because it is much easier to understand how the cases fit together.
Indeed, and that my lady's comment is rightly made and heard on this side. It's our responsibility. It has to get those matters right.
Right. So now we turn to
the core bundle and the First-Tier Tribunal judgment at tab 11, page 4. And so you can see for paragraph 10 on page 95 that there were, at the top of page 96, that there were 3 issues in dispute. Really concerned with the third one, the surplus activities in the United Kingdom. And then you can see that the findings, page 97 from paragraph 18 onwards, as I mentioned earlier, even his nationality was in dispute. That was satisfied. He is Iranian. From page 98, paragraph 25 onwards, that the activities in Iran for the KDPI, of course, that's been disbelieved. At page 99, paragraph 33, when they refer to risk on return, they're meaning on the basis of his in-country claim in Iran, not at that point, not in relation to the. So far, based on his case, based on his past alleged parties. That's disbelieved, no risk on the basis of that. And then as far as the surplus activities are concerned...
Well, at 34, the tribunal judge refers to HP.
Yes, indeed, my lord. And for the proposition that Kurdish ethnicity alone is insufficient.
Yes.
And then the tribunal then goes on to consider the surplus claim as a separate element from paragraph 35 onwards, citing the law which we've now looked at, of course,
yes.
XX, in relation to...
Is there any error in 35 or 36 or 37?
No.
38?
No, my lord. No.
Right.
And so 36 XX is obviously then the BA criteria are set out, and then also from paragraph 41 at page 102.
41 correct? Is there anything that is criticised in 41?
No, my lord. It's a record of what was held in BA, my lord.
Yes.
It has a, and so the discussion begins from paragraph 42 onwards. And that deals with the both with the demonstrations and with the social media material, and the evidence before the tribunal in that case, including the testimony of the oral testimony of the appellant, is considered here. The appellant, paragraph 43, said he attended between 8 and 10 demonstrations in the United Kingdom. Then the tribunal goes on to look at what his Facebook material could establish. Now, it's right to note that his Facebook material wasn't in the correct format that was required on the authority of XX for the way in which materials should be presented, and so it has been, the weight given to it is obviously discounted on that basis. But what the evidence did show was that he had been outside the social media evidence. He'd been outside the demonstrations at the Iranian embassy on the occasion.
Just so I'm clear, there's no criticism of the way the tribunal dealt with the social media evidence. We're just focusing.
Yes. It's
just the embassy attendance.
Yes. If I've been unclear, I apologise. Our focus is on whether or not he would have the risk of him being filmed in the crowd outside the Iranian embassy, not on the social media. I haven't taken my lords and my lady to any of the social media authorities because they're not an issue today. And so what you can see at top of page 103 is the occasions on which it could be established from the social media evidence that he had been outside the Iranian embassy. So he said 8 to 10 occasions, and the tribunal is able to establish it, those 6 days.
There were 6 at least,
and so the final date is the 25th of February 2024. The hearing is obviously, this first-tier tribunal hearing is in March 2024. So this list of demonstrations is down to the date of the hearing. And then when the appellant, when the tribunal is talking about what the photographs show, it's talking about as they appear on the social media that has been provided. So the quotations in there that you see in paragraph 46 are on the photographs as they appear on social media, not and so you can see there that he says in 46, my participation as an oppressed Kurdish individual in the demonstrations against the Islamic Republic of Iran, against the system of oppression that exists, a system thirsty with blood of all those who don't have opinions. I mean, it's syntactically obviously difficult, with system against the Kurds, against freedom, against religion, against making a living.
But those are captions added to the photographs. He wasn't standing outside the embassy with a sign saying...
That's why I made the point to my lord, yes, it has. And again at 47, a similar point. And then...
Sorry, can I just ask,
yes,
just for my information, please, what's a kolber, K-O-L-B-E-R?
It's a person who carries goods in the hillsides of northern Iran and into Iraq. It's a job, and it's almost a trade as a profession. So there's group of people which do it, and I think it runs in families. And so those sorts of people cross borders. And so in a migration setting, the question of how they're treated, they're viewed suspiciously by the Iranian authorities because they can convey goods and people.
Well, that was a very helpful explanation.
That's very off the cuff.
I didn't know what it meant.
I'm not claiming any expertise.
No, thank you very much.
I was looking with the phone just to make sure who has a similar experience in these cases.
All right, thank you very much, Mr. Barry.
Yes, so that's why it's mentioned in any event.
Yes,
that would be a known thing. And then paragraph 48, then this is about the A4 piece of paper. You remember I took you to the photograph, exactly. And then it says, of course, in 48, in some of the photographs, the appellant is shown wearing a high visibility vest, although he did not suggest in his written or oral evidence that he played a high-profile organisational role in the demonstrations. There were then other posts which are recorded at 49, and then the paragraph 50, which is important. In the light of photographic evidence, I accept the appellant has attended the demonstrations referred to above. However, in my judgment, his attendance at the demonstrations and his Facebook posts more generally are sporadic in nature and characterised by a flurry of activity, followed by a lengthy pause and a further flurry months later. The appellant's online activities referred to above are clustered around the immediate aftermath of the respondent's refusal of his protection claim and the months before the hearing of this appeal and the date of the appellant's witness statement in this appeal.
Is that analysis correct?
Well, we will, in my submissions on ground one, I will take issue with the way in which the reasoning is approached in that paragraph.
But what's wrong with it? You don't like the word sporadic? He's just saying it's not every Monday morning 9 till 10. It's sporadic. It happens from time to time, and that's the first thing. And that's just a word that he's used, and he's characterised it as activity with activity, a pause of some months, and then more activity, and you can see that from the dates. And then he says it's clustered around 2 other dates, and I haven't checked the date of the refusal. But the date of the hearing is right, because that was February, wasn't it?
Yes, indeed, my lord. Yes, so the hearing.
I mean, that's just his, or 8 March. That's just his description of the facts he set out. I mean, can that possibly be an error of law?
Well, my lord, we do take issue with the language used. We do say there's materiality, and these descriptions are used pejoratively to dismiss the weight of what's being done. The encounter, the point which we put at the front and centre of this is that there are 6 occasions on which there is a risk of being filmed in demonstrations.
Right.
And to be absolutely clear, it's like the question is, what is the perception of the Iranian authorities to somebody who? How do they view it? To characterise something as sporadic in nature, sort of judgment that obviously someone in this jurisdiction, whether it's a Home Office advisor, a lawyer, somebody might look at these and judge that. But what matters is how being in a demonstration, visible and participating.
I understand that. You're going to come to your submission.
I am. Yes.
Because there's a prior question.
Yes.
And I think the prior question, when we get there, is addressed in paragraph 54. You're on paragraph 50.
I am paragraph 50. And then you can see at paragraph 51 that the appellant's witness statement explanation, which I've already taken my lords and my lady to, is recorded there, and this is for the purpose of him trying to explain how he came to be politicised. And then 52 that he's not held to have any. His activities are held to be contrived,
exactly,
both in respect of in person and online. And then to 54, the tribunal goes on to consider that merely because he'd not engaged in genuine political activity, that does not necessarily mean that his activities would not be known to the Iranian authorities and perceived as political activity, giving rise to a real risk of persecution.
So I am therefore required to consider whether the attendance and social media activity would have come to the attention of the Iranian authorities. That's why I was describing as the prior
It
question.
is. It's the identification
So
question.
yes. So that is. Does that correctly identify the relevant issue?
That correctly identifies the ground one issue, the identification question.
Yes.
I understand where the reason my lord asked that question. It is. I have to go on to consider, notwithstanding the judge, that these activities are opportunistic. Nonetheless.
Well, all I was trying to seek from you is whether you accept that is the tribunal judge asking himself the right question about the, to phrase it slightly differently, the risk that the appellant's attendance and social activity would have come to the attention of the Iranian authorities.
Yes, the only quality clarification addition I would make is not would have come at the risk of it, as my lord said just now, that it's not would they have come to the attention of the Iranian authorities, is there a risk they would come?
Well, if the tribunal judge decides that...
A real risk, yes, my lady, yes.
Sorry, it's language, yes.
So the standard test. So the question is about risk of it coming to attention, not would have come, because that implies certainty.
I understand that. Okay.
And then the assessment at paragraph 55, clearly at the heart of where we are, that the appellant cannot be described as a regular or frequent attendee at demonstrations against the Iranian authorities. I accept that the appellant has attended more than one or two demonstrations, and that he attended demonstrations more regularly in the months immediately before the hearing of this appeal. However, viewed in the overall context of his time in the United Kingdom, his attendance at demonstrations and his online activity more generally is, in my judgment, sporadic and irregular.
Yes.
Right. And then 56, the wording of the Facebook post shown to me expresses the appellant's dissatisfaction with the Iranian regime. It's slightly more than that in my submission if one looks at the quotations at 46 and 47.
It doesn't matter because he switched at 55 from the demonstrations. He's then looking at the Facebook, and you've told us that you're not worried about the Facebook.
No,
at 58 he returns to the demonstration.
Precisely, my lord. I'm just making sure I haven't omitted any consideration.
Yes.
And then 58, as my lord rightly identifies, this focus turns back to the demonstrations. There's nothing in the appellant's evidence that would tend to suggest that he has led, organised, or otherwise played a significant role in any of the demonstrations. To the contrary, the appellant appears in the photographs showing to me to be an ordinary member of the crowd. I just pause there and recall in BA at 64, when one was an ordinary member of the crowd, there was a sub-question about whether you were active or passive as the language used in the judgment. So there could be, if I put it like this, there could be an aggravating factor that one could be an ordinary member of the crowd but be an active participant.
Okay. That's what he's going to consider the next sentence, because he goes on to what he was doing as an ordinary member of the crowd, and he's got a photograph in some of them, but you can't tell what the poster or paper was saying.
Yes, indeed. And in fact, that's why I took my lords and my lady to the asylum interview at the outset, where he said he was holding up a picture of Khomeini in there, because the photograph that we have, you can't see what's on the picture, but his evidence in his asylum interview is that it was a picture of Khomeini.
But we're not dealing with that. We're dealing with the judge's findings. We can't go behind 58.
Agreed. It's simply that if you were there, you wouldn't have a grainy photograph. It's we who have the grainy photograph.
Yes.
And then at 59, there's no evidence of the appellant's attendance at demonstrations has been covered in the media. We don't need to trouble ourselves with 60 and 61.
Do you accept the finding in paragraph 59?
Yes.
All right.
Yes. And 60 and 61 we don't need to deal with, because that's an issue that's not pursued in this court.
Yes.
It was taken about departing from country guidance cases. And then so the identification question, what you might call the ground one issue, is then concluded at 62 that there's no applying the authorities that we've looked at. not present any serious possibility that the appellant's attendance at demonstrations referred to above has come to the attention of the Iranian authorities. And then what proceeds further is we're straying into the ground 2 territory about risk on return. There are 2 pinch points, as this court is well familiar with. The first is when you apply for an emergency travel document from the Iranian authorities in order to travel back if you're undocumented.
Yes.
And
Yes.
the second one is what happens on your return to Iran. And 63 is concerned with the deletion of the Facebook account. We don't need to deal with that because that's not this case before this court. And so is 64. And so the sole paragraph in relation to the pinch point 2 issue for these purposes is paragraph 65 in relation to the demonstration. And what it says is, I mean, well, you can read it for yourself, but I can read it as is that.
Well, I think you can take it that we've read it.
Yeah, I'm grateful.
But it's the judge there repeats that he's there's not a real risk of identification.
Yes, it's how he does it, my lord, that I just want to. But if we just look at it just for a second, the submission was that the appellant may be questioned about his participation in diaspora activities, such as demonstrations and social media activity, that the appellant would either have to disclose this or deny the activity in the knowledge that his lie would be exposed through intelligence gathering systems. So it's not about whether or not he has a genuine belief, it's about whether he discloses,
Yes.
which is accepted that he was at those demonstrations.
Yes.
Should he or deny the activity in the knowledge that the lie would be exposed through intelligence gathering systems. And then what the tribunal says is that this concern, however this concern falls to be considered in the light of the finding in BA, that the ability of the Iranian regime to identify all returnees who have attended demonstrations remains limited. And then it quotes a passage from the back end of paragraph 66 that my Lord Justice Lewis rightly drew to my attention as salient in that paragraph. And I will come on to make my submissions on this, but this is the sole paragraph on risk on return based on the demonstrations that it's accepted that he was at the demonstrations. There's a finding which we hope to interrogate too in ground 1 submissions that it's unsafe. And then in respect of, we know that he was there even if what will happen to him on return. What's being posed here is the question at pinch point 2, not what would you ask, what would we say in response to questioning? In other words, not simply about the question of identification on the assumption that you're not identified, but you go back on something that there isn't a risk of identification, but you go back and there you are in Tehran airport and you're being questioned, and the question and the what would you say in that situation, and if you're asked. And so it's different. The reason I draw this and put this squarely before the court is that with the Facebook material, when you have social media, you can delete your own account. And in fact, the authority of XX is that a person who wishes to avoid persecution, it would be reasonable for them to do so. But if you're at risk of being filmed, it's not in your gift to delete something.
What the judge says is, what Mr. Solomon was saying was, look, he'll be asked about the diaspora activities, about the demonstrations, and then he's either going to have to say, oh, I wasn't there, and they say, no, that's not true, you're lying. Look. But what the judge then goes on to say is, in fact, on the facts of this case, they won't have the photographs, they won't have the material showing he's at the demonstrations for the reasons that he's given. So that's what the judge has found, and the question is, why is that wrong?
So I'll come on to it in ground 2 submissions, but just as foreshadow is that the dilemma promotes the possibility that you may disclose that you were at the demonstration. You don't know. Dilemma, obviously, there are 2 poor options. Your options are in genuine.
You're not going to be asked about them and found out because there's no risk, no real risk, no serious possibility of them knowing about the presence because he was a face of the crime. That's what the judge seems to be saying. He doesn't have to volunteer them because he doesn't really believe them and he didn't take part. But I mean, 65 is he's not going to be questioned about photographs of his attendance at the embassy because they're not going to have come to the Iranian authorities' attention. That's what it's saying.
Well, the questioning, the way it's put, I understand the way the submission is put there, but what the focus is on what does he say in response to being questioning about what he's doing in the UK. He's put to a dilemma about how to answer that question.
No, he just says, I haven't taken part in activities intended to support.
And that
he doesn't have to volunteer it. If he's asked it, he doesn't have to lie, because when he was there, he wasn't actually supporting the Kurds.
Yeah, but he was at the demonstrations, my lord.
Yes, they would know he was at demonstrations.
He doesn't... Yeah.
This is saying, if they ask him, it wasn't discussed, if they ask him, all the other cases say he doesn't have to say anything about it because it's not true. This is predicated on the basis that he'll be caught out. He'll say, no, I've had nothing to do with demonstrations. And they'll say, look at the photographs, you were there. And the judge has already found that the photographs wouldn't have, or the identification issue, this wouldn't have come to the attention of the Iranian authorities. So they're not going to catch him out in a lie because they haven't got the photographs to do that. And he's not going to be lying because he didn't believe what he was doing there.
So your point is a different point, as I understand it,
Yes.
Mr. Berry. Your point is, if he's asked, have you ever been to a demonstration in the UK? So he's just asked that random question when he gets back. He is then on the horns of a dilemma because he doesn't know whether or not there is evidence to show that he was. That's your point.
Yes,
Isn't it?
Yeah,
and so
right.
he may create the risk by saying, so he's forced to say, if I say no and they know, if I say I haven't been at any demonstrations and I know, and they do in fact know, I may be punished further. So his subjective concern is, how do I answer this question? We know that he's been at the demonstrations. We
Yes.
also know from the First-Tier Tribunal that they don't believe that he's at risk of identification. But he goes back and he has to answer that question. And my lady has exactly the point that I am trying to make. It is that, how does he answer that question? If he answers it, I wasn't at the demonstrations, and they know he was, right, then he might be harmed further. So he might have an incentive to confess, and that creates a risk moment, because they didn't know, but now he's told them. And he was, so now they have something to look for in their files, which we know that they have, of city demonstration photographs.
Is this a gap submission?
Yes.
Right.
Precisely, my
It
lord.
means anyone who takes part in one demonstration will always be able to claim asylum, because they will say, I can never be sure that wasn't the one they photographed me. I will always be on the horns of a dilemma. So I must win. That's the submission.
No, the submission, my lord, is not that. The submission, my lord, is that the First-Tier Tribunal need to consider that question and form a conclusion on it.
Right.
So it's not that everyone's a winner on that basis. This isn't one of those propositions on that, but far from it. What it is that the First-Tier Tribunal judge, having the only piece of evidence in front of them that is found credible, which is that he was at these 6 demonstrations,
Yes.
has to consider how he would... If they do that, and he takes his chances with that question, let me be very clear. If he's in the First-Tier Tribunal and he's asked how he would respond to that question, and the tribunal judge finds no risk in the light of his answer, game over. He doesn't win. He loses his appeal. But for these purposes, where we are today, the question is, should the First-Tier Tribunal judge have considered that question?
Okay.
But if you read paragraph 65, Mr. Berry,
Yes.
it doesn't look as though that's the way it was put in the FTT. The way it was put in the FTT is different. He denies the activity in the knowledge that the lie would be exposed through intelligence gathering systems. That's a reference to the Iranian authorities having some method of collecting all the photographs they may or may not have taken at embassies all around the world where there are demonstrations, and then examining all those presumably hundreds of thousands of photographs of people when somebody rocks up at the airport and saying, oh, yes, that's him.
Well, the evidence that we looked at was from that report was that they collect it by cities, and so he's off the flight from London.
But
flight
how many demonstrations outside the Iranian embassy have there been? I think he arrived in September 2021. How many demonstrations have there been outside the Iranian embassy?
I don't have the figure to hand, my lady,
but
but
attended them, and how many photographs will they have? I'm just trying to work through the
I do appreciate there is a task there, and the question is, of course, of the risk of having been photographed, not of the certainty of having been photographed. But we know from the authorities that the Iranian regime has not become more kindly disposed towards diaspora dissidents who are protesting outside its embassies. If anything, their reaction towards the Iranian diaspora has become more malevolent in terms of its wish to surveil them and to control them in their dissident activity. That's the trend of the guidance cases we've been examining. And so it's all about risk. It's not about. I agree with my lady's proposition. There can be no certainties given the scale of.
Where's the evidence that the Iranian authorities collate their photographs by reference to individual cities?
Your problem, with greatest respect, is what you're doing, I think, is taking the description of background evidence in the BA case,
yes,
which you took us through.
Yes.
But then you've got to read the conclusions. And the fact of the matter is, you just don't like that conclusion in paragraph 66, which says, we conclude, therefore, that for infrequent demonstrators who plays no part in demonstrations and participation not highlighted in the media, that there's not a real risk of identification. You don't like the conclusion and you think it's not sustained by the evidence. But given that that is the conclusion, the problem that seems to me to be present in this appeal is that's precisely what the FTT judge has done. He's taken that conclusion. He's decided that he's not going to be at risk of identification. Therefore, there's no real risk in him being returned. And all this difficult questions about what does he say at the airport if he is asked and so on, he can rest assured because he can rely on paragraph 67 because that's the finding of fact and he will have to rely on 66. But if that's the conclusion in BA, going back to earlier bits of the evidence, which if the tribunal had chosen to accept it would have led to a different conclusion, doesn't help, does it?
But the dilemma is different. The dilemma here is it arises even in the context where you were not at risk of identification initially. So they don't know that you've been at demonstrations when they ask you, what have you been up to? Obviously, if they know that you've been at demonstrations, he's at risk. That's
yeah, but he's not.
But no, exactly on that basis, yes. But in relation to the question, then the dilemma arises where you don't know how to answer the question because you could expose yourself to risk. It's like, but so if you want...
This case is saying he won't have to worry about that because he's not going to be asked the question.
Well, he's going to be asked. He goes back. So on the authority of BA and HB, he goes back for questions to be asked because he's an ethnic Kurd who without documented.
He's not going to say, firstly, he's not going to say, I was demonstrating support of the Kurds, because he wasn't. That's the finding. He just contrived an opportunity.
In support of
wasn't doing
Kurds.
Then the question is, will he be able to worry about the fact that, well, if I say that, they'll catch me out because they'll have a photograph that shows me at the embassy and they'll say, why are you saying you weren't in support of the Kurds when you were at the embassy? And the answer is, there's no risk that they will have a record of that according to paragraph 66. So he's not going to be asked, he's not going to be caught out in a lie, and he doesn't have to lie because it's not a lie because he doesn't support the Kurds. That's not why he was there.
Well,
that's the difficulty that I've got.
The motivation.
Mr. Berry, sorry, I'm going to because I see the time.
Yeah.
And you've still got to come to your submissions on
yes,
the ground.
Yes, we have foreshadowed them, so I will be.
So I think.
Yeah.
So I think. Can we park that question if it reemerges?
Of course.
Yes.
But you finished with your analysis of the decision.
Yes.
So can we go to your
Yes,
ground?
of course. Yep. So what I would.
Sorry, Mr. Berry, you weren't going to answer my question.
Apologies, my lady.
Do you remember I asked? I think you said there was evidence that the Iranian authorities collect photographs by reference to cities, and I was just asking for.
We looked at it, and I think it was in.
I didn't pick that up.
Either in HB or in.
Don't worry. Don't waste time now. If you could
yes,
just let me
if
know
I can.
in due course,
It's it's the other. It's either in HB or BA.
It was one of the cases.
Yeah.
And I will give you the reference
Yes,
for lunch.
absolutely. I don't want you to waste time now. Thank you very
Junior
much.
will get it.
It might be around paragraphs 29 and 30 of, I think it's BA actually.
Yeah.
30 of BA, they're filming quite a lot. Any intelligent person would assume they're sending the footage back to Iran. That's what I think you're relying on.
That's the first one, but there was also an extract from a report.
There was.
Which
41, I believe.
41
41
in,
then, yeah.
648.
I'm very grateful. Yes, it has,
Background evidence in BA. I think.
yes, indeed. The material is sorted
Yeah.
at the point of return. They have a city organised by cities, and then the evidence was that the airline staff hand over the names for the flight manifest.
so it's the quote in paragraph 41 from the report published in 2010.
Yes, and that's obviously a vintage, but BA has been endorsed subsequently, most recently in XX, and of course technology.
No, I understand that. I'm just positioning where it is.
Yes, indeed.
Photographs, they searched the cities where that was where the individual was heading to. Interestingly, the other way around. Yes.
And
Anything
so,
else, Elisabeth, on that?
yes.
My lady also asked you the question whether the way in which it was put below was that seemed to be slightly differently from the way it's being put now. Can you come to that when you come to ground 2?
Yes.
Thank you.
Yes, and, of course,
Yes. So returning to ground 1.
And so so I don't think I need to take you to the Upper Tribunal judgment in detail because it unless I can proceed.
Well, if the FTT was wrong, then the Upper Tribunal was wrong to say the FTT was not wrong.
Yes, and so I don't wish to waste time. But it's in in our skeleton argument we set out what we say about it. So you have all our submissions. I doubt I can improve upon them. And so turning to the submissions in relation to ground 1, the identification question, just to give you the reference for when you look at the skeleton later, it's from paragraph 56 onwards in our skeleton. But I'm not going to go through the skeleton. I'm just going to give you the.
Sorry, paragraph
56.
56.
Onwards in the skeleton.
Thank you.
When
Yes.
You're matching the oral submissions to the skeleton. So it's so in respect of the ground 1 points, we say that there are 4 material flaws in the judgment in respect to the identification question. But in respect to paragraph 50, which we looked at in the judgment about the attendance being sporadic in nature, we say that I submit that the attendance, that the way it's recorded there, the focus is on irregularity and frequency and perhaps a want of pace. But what matters, looking at paragraph 64 of BA, is whether there is a repeated visible presence at demonstrations. Is it 1 or 2 demonstrations or is it regular? There's no warrant in paragraph 64 of BA Iran for looking at these things in this way. The question is, simply the term regular is used, not to provide a hard-edged term which you have to satisfy, but the question is it 1 or 2 or is it regular? And this is expanding that. He goes on at least 6 demonstrations, that are the ones that are recorded on the Facebook profile at the top of page 103 of the judgment in paragraph 45. And it's the connection of those accepted 6 attendances with the risk of being filmed, which is what you get from paragraph 65 of BA. There are spotters in the crowd, there's filming from the Iranian embassy. And what needs to be assessed there is there a risk arising from that, from the fact that's actually found? That he's
sorry I thought your submission is that all relate to ground 1, the risk of being filmed.
That's ground 1, yes.
Yes, which was what we're dealing with, isn't it?
Yes. My apologies.
And again, as I understand it, this is a gap submission that the tribunal judge should have expressly addressed whether there was a risk of being filmed arising out of his attendance at 6 demonstrations. Is that
yes,
I mean, is that the overarching? And because you've gone straight into form material forms and you're picking up one word in one paragraph and saying sporadic.
Well, it's the way in which. So in paragraph 50.
Yeah, but is the overarching submission that
Yes.
there is a gap,
Yes.
a material gap,
And then I'm turning.
in that the judge had to,
Yeah.
as a matter of law, specifically determine whether or not there was a real risk of the appellant being filmed
Yes.
as a result of his attendance at these demonstrations.
Yes, it's the overarching.
And the absence of that specific fact issue being addressed undermines his
Indeed.
right.
My lord,
Okay,
point.
that's
And then
it.
That's it. That's the
Okay.
overarching
Thank
submission. And
these are the elements.
These are the elements
that we're relying on in support of that overarching.
these are the elements of what the judge actually did do.
Okay.
So
One is you criticise the use of the word sporadic.
and
in
flurry,
paragraph 50, and
flurry twice. And the reason is the risk arises from how the Iranians look at it, not from how a sort of person. So they're not concerned with, there's no suggestion. If they have spotters and they have people filming demonstrations, the fact that it might be a flurry or sporadic it's not the point. The point is that there is a risk of being filmed. It has
Yes.
it's and so to look at it in this way in order to dismiss it, to use this sort of adverbial adjectival approach to qualifying the activity, is to override the fact that it's his repeated visible presence to Iranian filmers that is the issue.
Might it be said that the risk of being filmed is subsumed in the question of whether there's a real risk of identification?
It's certainly the core reason for why he might be identified.
No, but isn't that the real issue? Is there a real risk of identification?
That is...
And the film is how.
Yes.
But
and
the core issue, which the judge has to address,
Yes.
is there a real risk of identification?
Yes, I agree.
Is that right?
And the only evidence in this case that bears on that question, my lord, is the filming.
No,
Or the risk of filming.
Yeah, okay.
Because the social media evidence...
So we've got the sporadic, you criticise sporadic and flurry.
Yes, and to give you the... We say that what you see from the evidence that was accepted by the First-Tier Tribunal is repeated visible presence at demonstrations.
Okay.
It's there physically. And wearing... and he's at risk of being filmed and spotted.
Right. So the second, you said there were 4 materials.
Yes, there are. And just to give my lords and my lady just one example of where you see how that can be made manifest in a judgment. It's in the authorities bundle at tab 19, the case of SA Iranian Arabs.
Tab 19.
Tab 19.
Sorry, what is made manifest?
About being spotted and being visible. If one looks at page 682.
Yes.
Paragraph 61, my lord. Apologies. It's the
Probably said that.
So this is a country guidance case from the same time as BA, but dealing with Iranian Arabs.
Yes.
And so it's an illustration of how making specific findings can make a difference. Where someone is found at a demonstration, it's accepted they were at demonstrations, plural, and the Upper Tribunal, in this case, with Mr. Justice Hickenbottom presiding, finds that, reading the third line down, in an age when a significant portion of the population permanently carries with it a camera as an accessory to a mobile phone, we consider it likely that a regime as nervous as that which is in power in Iran would routinely photograph those who demonstrate against it. He then goes on to say it is less easy to see how such people would be identified. And then,
yes, they come to the conclusion, reasonably likely. Can you just tell me, this is a
different cohort to Kurds. It's about Iranian.
No, it's not that. I was looking at what's the basis of the Upper Tribunal's the appellant gave oral evidence. So this was a rehearing.
Yes.
Okay.
Yes.
So this was a rehearing. They heard oral evidence. They considered the facts and came to the conclusion that it's reasonably likely that this appellant would have done enough for his name to have come to the attention of the Iranian authorities.
Yes, it's only an illustration, not there's no legal proposition here, but just if I was asked...
Well, there are cases where people will do enough to come to the attention of the... Yes, okay.
But the risk is... it's really about the filming, my lord. I drew my lord's attention to that passage. It has...
Paragraph 27 seems to be the description of the facts of these particular demonstrations. 4 political demonstrations, following the killing of Arab demonstrators.
Maximum number of people at the demonstration was 20.
Yeah. He was wearing a fluorescent jacket, standing in a prominent position, some of which have been posted on a group's website. In another one, he stood in front of the Iranian embassy.
My lords, there was also, my lady, there was also activist and detention history in Iran, which you'll see from paragraph 18.
My lord, my lady, I should be clear. I'm not suggesting this case is on all fours with this case.
That's the trouble. It's with taking... Anyway, we've...
all I wanted to show, if my lord wanted just show you an illustration of where the finding about being filmed can make a material difference.
Okay, thank you.
It has a... that's
yep.
it.
Thank you.
And then a paragraph... So the second point is that at paragraph 55, the tribunal doubles down on its assessment of the protesting and its significance by saying, however viewed in the overall context of his time spent in the United Kingdom, his attendance at demonstrations and...
sporadic and irregular.
Irregular, yes. But my submission is the question of risk from the Iranians. That it cannot be that the Iranians measure the risk of identification is what proportion of his time in the UK has been spent demonstrating.
No, but if your attendance at demonstrations was not sporadic, but was regular, that would be relevant.
Frequent. Regular in the sense of doing it a lot. If I can put regular rather than
what I'm saying
like
is,
a month at part or something.
The number, the dates, everything, the regularity, the frequency, must be relevant.
If you're going on 6, 7, 8 demonstrations, that's more than 1 or 2 clearly, and the risk of you being photographed could be higher. If you went on 1 demonstration, but you were the leader of a movement, you wouldn't need to go on many. So regularity would be.
You seem to be saying, I can't work out whether your submission is that sporadic and irregular are misdescriptions of what happened in this case, or to take into account that demonstration, your attendance is sporadic and irregular, is a material error of law.
Well, first of all, there's no warrant in BA for sporadic and irregular.
So you are criticising the language.
I am criticising the language, but also in my submission, it's meaningless from the point of view of identifying whether the Iranians might have identified it.
What about? But it doesn't matter what language the FTT used. You have to submit that it was perverse of the FTT to find that somebody who'd attended 6 demonstrations in accordance with the pattern that the FTT discerned, a pattern that only started just after the refusal of his asylum came in 2023, the circumstances really being here from September 2021, that finding is perverse. It doesn't matter whether they used the right or the wrong description of that pattern of attendance.
Well, in my submission, my lady, it does matter for these reasons that the way in which to approach assessment of risk where there is accepted participation in demonstrations is to make an express finding about whether or not there is a risk of him being filmed. And calling it sporadic, it's not just that there's no warrant for it in BA, it's deployed pejoratively to dismiss the participation without any connection, instrumental connection, to how the Iranians would view it. There's no, so in paragraph 55, the suggestion that the overall context of his time spent in the United Kingdom is something the Iranians would if one is, it's them who are the source of the risk. And that's not a relevant consideration if you're a hostile regime trying to suppress dissidents. Oh, well, he only hasn't been in the UK very long, or it's only 10% of his time in the UK. That can't be right. It's really whether his repeated attendance at, and regular in that sense, at demonstrations creates risk. That's what we need an express finding about, not the pattern, the rhythm, the pace of his participation, the proportion of his time in the UK. Those are not material considerations in my submission to how the Iranians would look at it.
Okay.
And so that's that point. And then the third submission relates to paragraph 58 and the holding that he appears in the photographs shown to me to be an ordinary member of the crowd. It is right to note that the tribunal goes on to say that though the appellant is often pictured holding a small poster or a piece of paper, there was no clear evidence for me of what was said. But the question from BA at 64 is whether he's an active or passive person as an ordinary member of the crowd. And whilst the piece of paper may not be visible to us because of the quality of the photograph that we have, that's not an issue that would have been true at the demonstration itself. The grainy picture is what we have. And he'd said in his asylum interview that it was of Khomeini. Did
you say that to the tribunal?
My lord, I'll get back to you. I haven't got it at my fingertips. But it was before, the asylum interview is before the tribunal.
No, but the tribunal proceeds on the evidence.
It does indeed. It does indeed. Written and oral, my lord, yes, it has indeed.
What is your fourth point then? Sorry,
yes. It's and on the question of this paragraph 59, the lack of media visibility, no evidence that it was covered in the media. If that factor were present, it would be an aggravating factor. You know, that he'd been in a magazine and anti to the regime, but its absence doesn't detract from the visibility of him being filmed. It's a non-fact. It's something that didn't happen. So therefore, it adds no value. But it doesn't detract from the value of the things which have been found to exist. And that one shouldn't. So this is my submission. Really, this is not a checklist, and it's not snakes and ladders when one looks at the criteria in paragraph 54 of BA. I accept that if he'd be better, and one can see cases where if you've been in an opposition journal, that would be the case. But if you are being filmed, you are being filmed, and no amount of magazine coverage or its absence makes any difference.
Right.
To that. So we say that that is in a sense is a logic flaw. That what we're looking at here is where does the framework from paragraph 64 of BA, where does it, on what's accepted is there risk, and what's accepted is that he was at demonstrations, and the authority of BA, which of course is country guidance for these matters, is that the demonstrations are filmed.
And just to be clear in my own mind, the logic flaw is that the tribunal judge needed to expressly address whether or not there was a risk of being filmed.
The logic flaw is if you look at the criteria in BA,
yes.
If one of them isn't satisfied because there's no evidence to support its existence, like being reported in a magazine or a newspaper, that the media coverage, then it's simply absent. It's neutral. What it doesn't do is detract from the evidence that does show risk. So if it's accepted that you're at 6 demonstrations,
yes.
And if it's accepted because it's country guidance that the Iranian authorities film demonstrations, your presence or absence in a magazine or a newspaper is not relevant to the risk created by the filming. It has, if you had been in a magazine, it would be an additional reason for being at risk.
Okay, but it is relevant to the risk of identification.
It means that it's relevant in the sense that if it was present, there would be an increased risk of identification. Yes, Mike.
Okay.
Yes.
So I think I understand. You're focusing on filming, risk of filming.
I'm taking an empirical approach to the evidence that was found, rather and that there is that conspicuous attendance at political events is the alpha and omega of this person's case, and that if it's found to exist, then so those are our submissions on ground one.
Thank you.
And we're not asking you. We're saying that if you're with us, that this is simply that the only task we're not asked to assess this is if it's perverse, if it's unsustainable on ground one. The conclusions we submit that you should send it back.
Right. Thank you.
And so that's ground one. And
yes.
And I should maybe speak before lunch, which would be.
Thank you.
Yeah. So on ground two, focus as we seen from page 105 of the with the First-Tier Tribunal judgment, the three paragraphs that we're dealing with, the question that relates to ground two, question of risk on return, pinch point 2 in the jargon. The first two, 63 and 64, were to deal with social media evidence, which is not of our concern. And then dealing with paragraph 65, again, we make 4 points. Firstly, the focus is in reliance on BA to say that on the submission that the appellant may be questioned about his participation in diaspora activities, and the submission made that he would either have to disclose this or deny the activity in the knowledge that the lie would be exposed. That the rebuttal of that or the rejection of that by the tribunal is in reliance on a finding in BA that there is no ability to identify all returnees who've attended demonstrations. But here the question is about risk. It's not whether he would be, it's whether he's at risk of being identified. What the tribunal was saying in BA when we looked at it was that there is no comprehensive facial recognition technology. That's accepted. That's the case. That's what BA says. It's country guidance. But that's not the question. The question is about risk on return.
I understand that, but what in my reading of it, the tribunal judge is doing is following on from his conclusion in paragraph 62 that there isn't any serious possibility that the appellant's attendance at the demonstrations has come to the attention of the authorities.
Yes.
So if the issue is risk of being identified, the tribunal judge has decided there isn't no real risk of being identified.
I understand my Lord's point, but Mr. Solomon's submission, which is made at the beginning of paragraph 65, is that it is taking, in my respectful submission, that's a little bit further than that, and that the appellant may be questioned about his participation.
Yes.
And that he would either have to disclose, not tell them, not respond to something they already know, or deny the activity in the knowledge that the lie would be exposed. And so that's the dilemma point that I was...
Yes, but exposed through intelligence gathering systems. Not...
Yes, but the observation... So the question is, so in the dilemma scenario, as I hope I was exploring with my lady earlier, is that he may inadvertently say, I was at demonstrations, but he doesn't know how to answer the question. If he answers it, I was not at demonstrations, and he has a subjective concern that they may know. He may fear that if I tell a lie, I will be treated worse. I will be, and so he may inadvertently say, I was at. They may not know that already, but we know that they have systems for checking things because we've seen that in BA at paragraph 40, and they may take that. The dilemma is that there's a risk, however you answer the question, that you make your situation worse. There's no good way out. So in the Facebook material question, he can delete his own material. He doesn't have to say it when he arrives on return. But he's not in control of the filming evidence. He can't just delete whatever the Iranians have recorded. So he doesn't know. The tribunal makes a finding. He's not at risk. But he has to answer the question, not knowing whether or not they have something.
I know, but the tribunal's made a finding.
Yes, they have.
So
They have.
I don't.
The dilemma is that he may answer it inadvertently, say something because he has a subjective concern. It's not that. So if he was at risk of identification on the tribunal's holding, we wouldn't get to the second question because.
No, I understand that. So the analysis is, even though the tribunal has found that he's not at risk of identification, nevertheless.
Yes.
Nevertheless. There's a risk that he might feel compelled to say, I attended demonstrations. Because he might think.
He might think.
So that there's a complete sort of
his
counterfactual
fear
there.
Is if I say no and they know, they may treat me worse for telling a lie. If I say yes, I'm telling them something.
I just don't understand how tribunals can do that when the tribunal judge has already made a finding. There's no real risk.
But they can ask him questions about it.
No, but how does that fit in with the first finding? If the tribunal has found that there's no real risk of identification, I don't see how the dilemma risk that you're talking about actually arises on the tribunal's analysis.
Yes, the tribunal holding on the first ground is he has not been identified effectively in the UK by the Iranian filmers at the embassy. Yeah. But he's nonetheless being returned as an ethnic Kurd who's on irregular, left without passport. And
none of which of itself is a problem, we know,
yes. And so that he's a sort of, if you like, in a suspect category, because it's not enough on its own, absolutely not enough on its own to be an ethnic Kurd with a regular exit and travelling back in an electronic travel document. But it means he's likely to be questioned.
Okay.
So there's an encounter.
Yes.
And then he knows, and the tribunal have accepted that he's been at 6 demonstrations. We know that he's not politically motivated, because that's the tribunal's holding.
Yes.
But we do know 2 things about the demonstrations. One, that he was there.
Yes.
2, that the authority of the country guidance is the Iranians are unimpressed by questions of were you motivated by political beliefs. They just see an opponent. It's the perception of the Iranians that matters. And so it's in that context that the dilemma arises.
And what evidence was adduced about this at the hearing?
Well,
I mean, did the appellant say, I would feel compelled, or I might accidentally say?
Not to my knowledge, no. But the point is, I'm looking at how the tribunal considered the question.
No, but the tribunal's determination is based on the evidence.
It is indeed, my lord.
And if there was no evidence that he would say, he felt, I would feel compelled to say, or I might accidentally say, or I'd be so worried that they would have they would know about my attendance that I would do this. Mm-hmm. If there was no evidence to that effect at all, which you're rather suggesting there wasn't,
we only have his fear subjective. All I can put before my lord is his fear at the last 2 paragraphs of his witness statement that he would be at risk on return, and also the way the submission is recorded in paragraph 65.
Do we have an appellant discussion? Was there an appellant discussion argument prepared for this FTT hearing?
There was.
I don't think if it's in the bundle, I haven't found it, but it may be that I've overlooked it.
I could just turn my back for 1
yes.
second. Well, my lady will have it checked. Oh, it's not in the bundle.
Could we be provided with copies, please?
Yes, my lady.
Because that may tell us what was being argued.
Indeed.
Because one way of reading this paragraph is that Mr. Solomons simply wasn't putting forward the argument that you're making now.
It is, my lady. I understand my lady's concern, and my Lord Justice Moylan asked me to come back on that question. It is my reading of it that he's being. It's about disclosure. It's about the dilemma. The way it says it's disclosed.
Well, we know what you're submitting.
Yes.
And we've read the paragraph.
And if we have the skeleton,
in a way, it doesn't help us.
Paragraph 35 actually says, due to my attendance at demonstrations in front of the Iranian embassy supporting KDPI and posts on social media. Well, social media posts can be deleted. He wasn't supporting KDPI, so we don't actually have any evidence at all from the witness statement, or you say, what is it orally, as to what the position would be when the tribunal found that there was no serious possibility. That's the problem. There isn't any evidence.
My Lord, I'll be checking what was said on the skeleton, and we will come back to you on it. And so the and my lord, I'm looking at the time. I don't know if my lord.
And we have peppered you with questions. I think it would be fair to say. I hope that
Yes.
like sporadic. They haven't been sporadic, regular,
frequent.
so should we stop now? What do you want?
15 minutes and see where we go.
How much longer are you going to be?
Well, my lord, I had thought I would be finished, but I might be 10, 15 minutes. It may be easier.
What do you want to do?
I carry on for 15 minutes and not ask any questions, promise.
Okay, well,
I mean, my
if
lord,
it's all right with you, we'll carry on. One of us has taken a vow of silence.
I can't ask anything
You'll find
else.
out which one in a moment.
I'll press on and see if I can.
Yes. Yes.
So and then
It would help actually if somebody's looking at the skeleton below, if they have it available, so you could deal. I see somebody is at the back, so they could.
I look at it over lunch and
Well, but we're going on for 1:15 to see where we are.
yes.
I mean, at the end, so
Right.
you may not have that opportunity.
I see. Yes.
Yeah.
How's that? We will try and get back to you then by 1:15.
Okay, thank you.
And so
You've done point one.
I've done point 1. Yes. It has,
You said there were 4 points.
there are indeed. And then on the second, the second point there is that the materiality of him when he's posed with that question on the basis that he is being presented with a dilemma is that they ought nonetheless have considered the fact that he had attended the demonstrations as a found fact at that point. So on this second question of that they would have considered as a found fact.
You mean the tribunal should have considered?
Yes, at that particular point.
Yes.
The third submission in relation to that is that there is no direction at that point in paragraph 65 in consideration of this, that it's the in relation to those accepted demonstration participations, that it's the perception that matters of the Iranian authorities, and that they have a low threshold for their suspicion. We looked at that in paragraphs 92 to 95 of HB, and the criteria which appear on the front piece of HB.
Yes.
The 10.
The sort of the hair trigger. Is that,
yes, exactly,
yes.
exactly, my lord. That's the 10th consideration there. And the fourth submission in relation to that is that in this question of how he confronts, but it really, the fourth submission, in a sense you have it because it's about the dilemma, my lord. It is. We just got onto it as an earlier point.
You mean how when the appellant is confronted with this, how he responds?
How does he answer the question? Yes, so it came up in answer to questions, and so I introduced it at an earlier point, and so we say, and essentially, that on this question of pinch point 2 on return, the paragraph 65 is just simply not doing enough work. Effectively, it's not looking at what we had in the light of the country guidance case. It's the full plenitude of the rubric at paragraph 64 of BA. It's taking a point about that there is no comprehensive surveillance and turning it as if that's an end to the question.
Can you remind me where the dilemma issue is dealt with in the authorities?
But it isn't, my lord, dealt with in those terms in that way.
Yes, okay.
It's a submission about what happens at pinch point 2
Yes.
on return. It just has and about how to approach it. It arises because of the way in which you cannot. It arises in the context of not knowing how to answer the question because there's no good answer, my lord, to the question. And the submission is that the tribunal ought to have considered that
ought to have considered
on Mr. Solomon's
the-
submission
yeah.
in for the ways that he would have to disclose or deny the activity in that context. My Lord, if I could just turn my back for one
And you're saying that, as you said, that 65 is an insufficient consideration
Treatment of
treatment of sort of what would happen as you're describing at pinch point 2.
Yes.
Yeah.
If I could.
Of course.
My Lord, I've been given the FTT skeleton
Yes.
argument. This is one paragraph
Okay, thank you.
for me just to have a look at.
And
I
this
haven't read it
is
yet.
the submission, the written submissions or case at the
Yeah.
as presented.
My Lord, if I could just have a minute to read it first. 'Cause I
Of
haven't
course.
had a
Yes,
look.
yes.
Apologies, it has a... My Lords, I do think you need to see, it's quite a long paragraph. I could have copies made. It is a submission that explains Mr. Solomon's...
Would you when you say how long, just read it out.
Should I read it to
Yes,
you? Yeah,
yes.
I'll just read it.
Yeah.
So it begins, even if it is not accepted, and I'm assuming that deals with the question of identification, but I haven't read the whole skeleton argument.
Yeah.
It is still necessary to consider the implications of A being questioned by the Iranian authorities in the context of him being Kurdish and unable to demonstrate that he left Iran lawfully. Such questioning is likely to relate to a range of issues, including participation in diaspora activities such as demonstrations and social media activity. Anyone subjected to such questioning who has participated in relevant diaspora activity is likely to be aware that the Iranian authorities have intelligence gathering systems and will consequently be placed in the invidious position of either having to admit participation or falsely deny such activity in the knowledge that their lie may be immediately exposed. Whether the Iranian authorities at the airport discover that A has demonstrated outside the Iranian embassy through admission, whether the Iranian authorities at the airport discover that A has demonstrated outside the Iranian embassy through admissions or other means, it makes no real difference to the risk. Furthermore, Lord Justice Sedley's observation in YB Eritrea against the Secretary of State for the Home Department, and then that was C Annex A, paragraph 17, then proceeds that, and then open quotation. The real question is likely to be whether the evidence indicates that a person is genuinely committed or merely a hanger-on has much less relevance to cases of Kurdish Iranians following HB Kurds Iran country guidance, given the hair-trigger approach to those suspected of or perceived to be involved in Kurdish political activities. That's the whole paragraph.
Thank you.
I can't tell you about the context because I haven't had a chance to look at it.
We'll be able to send that through.
Yes, indeed. We'll send copies of the whole skeleton to the court,
Yes.
of course. But it does flesh out the summary of Mr. Solomon's submission at paragraph 65 as it's recorded in the First-Tier Tribunal's judgment. And it's obviously a quotation from Lord Justice Sedley's observation in YB Eritrea, which is in the 30s, I think. At tab 22 at 785, if we want to have a look at that. And quotation, my lord, from page 790, tab 22.
Thank you.
Paragraph 13.
Yes.
Sorry, I thought there was a suggestion in the paragraph of the ASA that you read that this is somehow linked to the hair trigger response, but this is all about Eritrea, so this doesn't deal with the hair trigger response at all. Quotation from YB Eritrea.
Sorry, my lady. It just deals with. I think it's an observation about subclass activity, my lady, just in the context of what can be objectively known and why credibility on things which are objectively known is of less impact, less material. Yes, and the point being made, my lady, is that that in the quotation I read from the skeleton argument, this is different to YB Eritrea because there is a hair trigger issue from respect of Iran. I'm grateful to my junior friend.
Yes, thank you. Do you have any questions? Do you have any questions? Do you want to rise for 5 minutes? We'll just rise for a few minutes. So I'm just coming in on my own, so we'll come back at 2:10. Thank you.